from the judge.
He does. He's got a press release.
Leave me alone. You're dismissed, buddy. Don't bark orders at me unless you know what's going on first. You understand me?
Don't tell me what to do.
Oh, I am telling what you do. I just did tell you what to do. Started off good. Let the games begin, bud. You want to talk or anything? I mean, do you have any plea deals for me? You want to dismiss the case? I suggest you do.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer, and yes, I am wearing big orange today in honor of my balls advancing to the Elite Eight. Haters gonna hate, I understand. Some of you might be offended by the bright nature of this color, and that's okay. Hopefully I'll be able to wear it again after the next game when we make it to the Final Four for the first time in the program's history. Now, on to the reason that we've all gathered here today. Today's case comes to us from a gentleman named Mark from the YouTube channel Press NH Now. And it depicts Mark as a First Amendment auditor having to argue a frivolous motion made by a prosecutor completely and intentionally misrepresenting the law. Now, the source video is 30 minutes long, so I've edited out all but the portions relevant to our discussion. But you still want to be sure to head over to Press NH Now's channel to watch the whole video and give them the credit for sharing their experience. Let's get into it.
Stand up, please.
Let's see how they react. You want to talk or anything? I mean, do you have any plea deals for me? You want to dismiss the case? I suggest you do.
We're just going to do the motion today.
Just going to do the motion today? Okay. I'd tell you good luck, but, you know, screw you.
No, not like that, man. You know what you did.
Let the fun begin, dude. He's
Bring
out.
on the press, bro.
He's going to be Facebook famous now and YouTube famous, just like this guy. Remember him, guys? He's YouTube famous.
Yes, that permission from the
He
judge.
does. He's got a press release.
Leave me alone. You're dismissed, buddy. Don't bark orders at me unless you know what's going on first. You understand me?
Don't tell me what to do.
Oh, I am telling what you do. I just did tell you what to do. Started off good. Let the games begin, bud.
All rise, please. Turn off. Take off your hats, please.
Good morning. You may be seated. Stacey, Marshall. Come on up, sir. Okay, we're on the record in the matter of Stacey, Mark, and Sean, docket number 44423 CR 586. Could the parties identify themselves, please, starting with the state?
Attorney George Wattendorf from State.
Thank you. Okay, so we're scheduled for a hearing on motion, so either hear from the state first. I did receive the defendant's response and objection. Did you receive that?
I just.
Okay. Do you need time to prepare, or are you all set to go?
Well said.
Okay.
Did the court want testimony or?
I think we need testimony.
Okay.
Who's testifying?
Lieutenant Sweeney.
Come on up. Here's your case. She's always swear or affirm that any testimony or evidence you give will be the truth, the whole truth, and nothing but the truth under the penalty of murder.
I did.
You have a seat. You may inquire.
State your name, spell it for the record.
Mark McSweeney, MCSWEENEY.
Did you receive a motion from discovery from the defendant?
Yes,
And did you process that?
yes.
How so?
I processed the body cam request by then providing that individual with the body cam footage, which is sent to them through the email address they provide.
And so you sent it to his email?
Correct.
And do you know if he accessed that?
He did.
Would that have been on or about September 15th?
Correct.
Okay. Did he download it?
Yes.
Do you know if he published that on his YouTube channel?
Yes.
Run the plate. Do your job, bro.
Is that your car?
I'm not going to answer those questions. I did not say you cannot. I did not say I'm not identified.
Take my camera down, okay? Quick switch phone down. Place you in front of your back. You're under arrest. What? Disorderly conduct. Breach of bail.
Just let you know I got a body cam on.
What's the breach of bail? Breach of bail because you're out on bail.
Okay.
What's the breach of bail? I don't understand. What bail condition am I violating? Your good behavior for disorderly conduct. What's disorderly? What's that? What's disorderly? Obstructing the government administration here.
Okay.
How's that? Because you're having people purposely flood our phone lines.
Oh, okay. All right. Just gonna let you know I'm gonna double lock them so they don't tighten up on you. Okay.
So you shut my camera off? I'm just turning it off. Yeah.
The woman said, you know,
I don't know the date that it was published.
September 18th? Is that,
I believe that's the date listed in the motion.
did you check to see if those videos are still there?
That
Our
video
body cam
with
videos?
the body cam video is still on the channel, on his channel, listed online.
As of today?
Correct, as of this morning.
No further questions?
Thank you. Do you have any questions?
So one of the interesting things about this case is that the prosecutor, George Wattendorf, filed a motion for the court to impose a preliminary injunction or protective order against Mark because the police department is displeased about the comments they received from his YouTube audience. But Wattendorf didn't just file the motion, he argued the law in a misleading way, and he did it to try and force Mark to remove some videos he's posted of his own arrests on his YouTube channel, which, as you know, would be a violation of Mark's First Amendment rights. The reason I wanted to talk about this case specifically is because it is a great catalyst for a discussion on how prosecutors should conduct themselves and who they actually serve. It's something I'm very passionate about as a former prosecutor, and I'll have to say 100% that the elected district attorney that I worked for always gave me the freedom to dismiss any case where, in my opinion, it was a bad case, allowed bad police conduct to continue, or didn't set a good precedent. Even if it was a situation where we had a discussion and one or both of us felt like there was more harm in allowing the police to think they could conduct themselves this way than there would be to allow this person to go free, even where they committed a crime, I had the freedom to dismiss that case, and I routinely did so. But I always felt like I was alone in my thinking that a prosecutor should be a gatekeeper to keep bad cases out of the criminal justice system. I was basically the only one in my office who would do things like dismiss cases at arraignment because the charging document was deficient, or outright dismiss cases without a motion from the other side. I just felt like, as a lawyer, you should know whether the case is a good case or a bad case, and if it's a bad case, it needs to be kicked out of the system immediately, and it doesn't really matter who does it. Our job, as I saw it, was to do the right thing. But again, I always kind of felt alone in that thinking. I don't say that to disparage anybody I used to work with or anything like that. It's just that I felt like that the way that I looked at the job was not in line with the way that other people looked at the job. Now, the biggest issue that I see with prosecutor conduct is one that kind of permeates all areas of government bureaucracy and specifically law enforcement. It's simply this: they believe they are the arbiters of legitimacy. By they, I mean the government, and what I mean by that is that they believe that they get to choose who is press and who's not. This is why you routinely see police officers asking auditors for their press pass or, their credentials, having no idea that no one actually issues those. And it's always kind of fun to watch auditors remind them of that, and they don't really have any good answers. But the bottom line is, they always want to try to question the legitimacy of what a person is doing when they claim to be a member of the press. I mean, after all, Mark didn't do anything that the local news wouldn't have done and do all the time with body cam footage they get pursuant to a FOIA request. What they're mad about is the fact that they don't like that Mark is exercising the First Amendment in a way that is less cooperative than the local news media, and they don't like getting the backlash from his audience. See, the local news media is just as bad as the government. They build these backroom relationships so they can have exclusive access to information. And we've seen how that plays out over the last decade when a handful of privileged people are in charge of what information gets out and how and who it gets to. Now, as it relates to the prosecutor's conduct here, first and foremost, all lawyers have a duty of candor to the court. This guy knows very well that what he's doing is disingenuous. He's essentially making the argument that the portion of the law that governs what law enforcement agencies do with their body-worn cameras applies to Mark, or citizens in general, and it also governs what Mark can do with his copy of the body-worn camera footage. Shockingly, this is despite the fact that the opening language in the law says that it applies to law enforcement agencies who equip their officers with body-worn cameras. Now, I don't know about you, but that doesn't sound like it applies to Mark or any other citizen. What seems to be lost on this clown is that the entire purpose of body-worn cameras is the protection of the public and the transparency of the government. The body-worn camera law is not to protect law enforcement agencies from public scrutiny. The argument is not only misleading, unethical, and likely violates the rules of professional conduct, but it's pathetic. Why would law enforcement need protection from the public? Their job is to serve the public. Instead of doing the right thing, allowing people to exercise their rights and just dealing with it, the lawyer here tries to manipulate the law and use it for the opposite of its intended purpose. This is basically the same argument that would be made if a doctor's office tried to tell someone that they couldn't release their own medical records because of HIPAA. which is, of course, preposterous. The medical provider has the duty of privacy protection, not the person who has the records. And the purpose of HIPAA is not to protect the medical providers. In the same way, the purpose of the body-worn camera provisions of the statute in question are not there to protect the government from the scary proposition that people might actually know what they're doing and how they're spending their tax dollars. One of the things the courts will do sometimes when applying a law is to look at the underlying legislative intent. That is, what was the legislature trying to accomplish by enacting this statute? Now, show of hands here, who in the room believes that when the New Hampshire legislature enacted this law, it did so for the purposes of providing an additional layer of protection for the custodians of the video footage? No? You either? Right. If that was the purpose, then why would they even write the law? I mean, law enforcement agencies have rooms of archived footage from arrests, and they've traditionally used every excuse imaginable to keep from releasing that to the public. Do we actually have to pretend that New Hampshire legislators decided to help them out with another law giving them a right to be less transparent? It's a ridiculous proposition, and this prosecutor should be ashamed of the argument that he tried to make to this court. Anyway, this stuff really aggravates me, but I thought it a good opportunity to read the opinion from the United States Supreme Court in the Berger versus United States case in 1935. Now, I know that's an old case, but I wanted to read an excerpt of that opinion because, in my estimation, there has never been a better explanation of the dichotomy associated with the duties of being a prosecutor. Prosecutors do not have a side except whatever side truth and justice is on. It's not like a plaintiff and a defendant in a civil case. Yes, a prosecutor represents the people of the state, but the job of a lawyer is to represent the interests of their client. And the people have just as much of an interest in law enforcement being held to the standard of doing things the right way as they do in prosecuting crime. And the people's interest in prosecuting crime is no more or less important than their interest in defending the constitutional rights of the accused, because after all, it is one of them standing accused of said crime. So I'll climb off my soapbox here and read the opinion in Berger. It is a beautiful one and perfectly describes the way things are supposed to work. The court basically scolded the prosecutor in this case and said that he overstepped the bounds of propriety and fairness which should characterize the conduct of such an officer in the prosecution of a criminal offense. He was guilty of misstating the facts in his cross-examination of witnesses, of assuming prejudicial facts not in evidence, of bullying and arguing with witnesses, and in general, conducting himself in a thoroughly indecorous and improper manner. But the excerpt that I really enjoy from Berger is the one that describes how a prosecutor is supposed to conduct themselves. And it says, essentially, a prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor, indeed, he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So they really smacked this prosecutor in Berger, and they really laid out the standard for what a prosecutor is supposed to do and how they're supposed to conduct themselves. It really is a difficult job if you do it the right way. Sadly, very few people do it the right way.
Present this to you. This is the state statute for New Hampshire revised statute for body cameras, 105D2, which is what he's stating in his motion.
Do you want to ask the lieutenant questions, or do you just want to argue the motion at this point in time?
I have nothing to say to him.
You have no questions for him? Okay,
No.
okay. Thank you, Lieutenant. You may step down. So, Mr. Marshall, I'm going to hear from the state first, and then I'll hear from you.
Okay, I also have a copy of the 105D. Now, just direct the court's attention to paragraph 12, where it indicates no person shall publish these in any manner.
May I object, Your Honor?
Sure, if you have a legal basis for the
I
objection.
do. It's in the statute. Chapter 1. This chapter shall apply to any law enforcement agency that elects to equip its law enforcement officers with body cameras. This statute applies to only law enforcement officers and constables and sheriffs, not myself or the public. And I stated that in my objection.
I'm going to overrule your objection. I'm going to let you speak to it when it's your turn. I'm just going to let him make his argument, and then you can make yours. Okay, sir?
Okay.
Go ahead.
So it's the state's position that the publication, broadcast by any person is prohibited, that it's strictly controlled as an evidentiary exhibit, and it is the property of the Hillsborough Police.
Objection, Your Honor, it's discovery. It's my evidence, and I have a right to publish it.
I'm going to, again, overrule your objection. I'm gonna let you say all of that.
Well, I mean, I have a right to object to.
You do. I'm
It's
gonna
irrelevant.
overrule the objection. I'm gonna let you address all of the arguments that he makes when you make your argument.
So there's no penalties, but there are protective orders that can be issued.
Anything else?
If the court rules in our favor, we ask that he remove him in 24 hours or be subject to contempt.
There's no penalty.
Anything else? Okay, now you may respond.
Yeah, if I can, since he's talking about protective orders or restraining orders, I also have the court rule for, give me 1 second please. The court rules for the elements to meet those criteria for restraining and protection order. If I can give this to you, Your Honor.
Sure.
He has not met any elements or guidelines in that rule stating that I am, that I met any of the criteria that he's stating. This too. Discovery. Sorry about that. I'll
That's
turn
okay.
court rules for discovery, Your Honor.
Okay.
And I've outlined everything that I can quote
Hold on,
into
before-
the objection.
Stop for 1 second.
Yeah.
So I'm looking at the first rule, set of rules that you gave me.
Yeah.
Is there a specific place that?
There is, it should be in the objection, Your Honor.
Okay,
If I can pull that up real quick and try to point you in the right direction. Give me 1 second.
take your time.
I think all I have, Your Honor, is the court rules regarding it. I did also apply all the elements of the articles for the New Hampshire Constitution in here too.
Okay,
Those should be quoted underneath each one in order.
okay.
Those do apply to some of those also.
As far as Rule 35 is concerned for
Yeah.
discovery, is there a particular part of 35 that you want me to look at?
I mean, Your Honor, I suggest you look at the whole thing to make a good finding on it. I did print that up for your convenience.
Okay, I just didn't know if there was a certain section you wanted me to draw my attention to.
It just doesn't apply.
I don't believe that I scored you in, so could you raise your right hand, please?
A little late for that.
Just about, because I'm treating this as
Okay.
evidence, not argument. Do you solemnly swear or affirm that any testimony or evidence you give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
So your testimony is that this document that you just handed me is on your YouTube channel as it is?
Right there in front of you.
Okay,
Redacted under my own accordance.
thank you. Anything else, sir?
No, the only thing I have on here really is, in light of the above objections on the last page of my objections, the defendant respectfully requests that the court, 1, 2, 3, and 4, if you want to read through those are my, that's what I like resolved out of this case. I would like a dismissal, based on these facts, that he can't even prove to the court, and it's frivolous, and it's malicious, and it's not what we pay for as taxpayers. I don't have a fair right of a trial because of these allegations. Like I said, it's frivolous, it's malicious, he didn't even quote half of the, I mean, he states that number 12, applies to the people, okay? It literally states on Title 1, the first chapter, this shall apply to law enforcement only, or to law enforcement. This is not a statute that applies to the general public, okay? It's public record, I have a right to publish it, I have a right to freedom of the press, and I urge this court to take that into consideration as he's treading carefully on my rights, and I don't approve of that, and I don't approve of this court making an order against it, or against mine.
Thank you. Do you wish to respond to anything that you said?
Just to go to his first argument, I agree that we do have to provide the body cams as discovery, because if there's statements made by him, so we do have to provide it, but he cannot legally publish that information on a public forum. There is that restriction in the statute that prohibits that, and we're asking for a protective order.
All right, I will take this matter under advisement. Thank you all very much.
Thank you.
Thank you.
Now, at the end of this motion hearing, the judge decides that she's going to take the arguments under advisement, and she decides to render an opinion later. And so we'll see, Mark, if you watch the video on his channel, go over to the courthouse and get a copy of the judge's opinion in the case. Mark ends up sharing the opinion on the video, and of course, the judge did deny their request to try and force Mark to take down the videos, but the judge is not without fault here because she also included what I believe is an illegal order for Mark not to post any future videos, which again I think is a violation of his First Amendment right. And to be honest, there's part of me that would kind of like to see him call her bluff on that one because I don't think she can impose such a duty on him, and I don't think it's grounds for him to be held in contempt if he violates the order. But Mark doesn't strike me as the kind of cat who just lays down and takes it, so it'll be interesting to see how he decides to conduct himself in the future, and once he posts a conclusion to the case, I'll be sure to update my channel as well. In closing, I just want to say that not only should this prosecutor be ashamed of the downright misleading argument he tried to perpetrate on the court, but anytime that as a lawyer you get your ass spanked in court by a pro se litigant, you should be wholly embarrassed, especially given the fact that the prosecutor has all the power. He should know when the case is weak and or non-existent. And what prevails when the smoke clears here is what we can all see, that this is an ego-based prosecution that attempts to enforce feelings and not law. And my opinion is that as the prosecutor, it is you that should be fixing this stuff on a law enforcement level. And so if the law enforcement messes this up and brings it to you, and you choose to proceed instead of slapping their hand and explaining what the law is, then you're no different than them. You ought to just put on a uniform and go down and answer calls and just violate people's rights like them, because you are not fully manifesting the opportunity that you have to be a constitutional gatekeeper. And that's a shame, because it's a position that should not be treated as anything other than that. If you're in a case and the only argument you can make requires you to lie to the court about the law, then you shouldn't be proceeding in the case to begin with. This is exactly why people rightfully do not trust their government. That's all for this one, guys. Thanks for all you do to support my channel. Please remember to like and subscribe and leave me a comment letting me know what you think of this video. I've left some other videos in the end screen for you to check out if you're interested. Until next time, take care of yourselves, always film your interactions with the police, and keep your evidence to yourself.